Telah berdiri internet. Yes.
When do you want after vacation? You submitted a denial also the applicant is not well.
Email number 23, my lord. My lord may be taken after vacation, my lord. I am submit to the translated copies. I am yet to get it from the translator. May be taken after vacation, my lord. This
He
is
will be
not
available after vacation.
definitely, my lord. I will definitely place before the court, my lord.
Finally, at the request of and calls for the applicant for filing the translated copies post on the reopening day.
Please.
It is again listed. What is the number that we should tell the court? Yes, post it for being mentioned tomorrow. Tomorrow it will come. Tomorrow it will come, we'll see. Post it under the caption for being mentioned. Yes. When did you take out the notice last time? When was the notice sent? We'll post this matter on Friday. Take steps. But land counsel for the appellant seeks time for taking steps to issuing notice to R1A. Post this matter on Friday. You said you will come up with some application. On 27/8/2000. Yes, this court has appointed yes. Incidence of death. How much was the claimed compensation? How much was awarded? Liability? Insurance. What was the age? Who is the first one? The two brothers. Let's see the hospital. Appellant number 1 is 34 years old. Who is handicapped?
Appellant number 2. Getting handicapped. Right now, accidents people. taken, you that.
Not the dependent. Hmm.
Some of the disease was there.
What do you say on that? About the loss of dependency?
You can get the data.
Hmm. Handicapped and the other one is a younger sister who is dependent on them.
That manner, they are not facing that. Only say. Now, he is always that, whatever the medical record of, he is placed before that, but I think it was placed.
Then what do you, what about the third person, third appellant?
Married,
No, she says she was, she's unmarried.
it is.
As on the date 26 years. No,
It is their to establish that. It is their duty to establish she is not married. Or whatever the document they have to got with the people. No, they are saying that not she is dependent. Only I will say, like the what the Supreme Court judgment, that they have to establish that they are staying with them and they are depending on the income of the deceased. What is the document they have got?
what is your counter on that? What is your objections on that?
It is them to establish. So that is being established. That there is not the effect.
So you say that,
50% of you.
no, according to you, what objections you have raised is only with regard to the driving license,
No.
para 6? After framing the issue. The respondent in number 2 filed the objections and raised the claim. Let's see. Hmm.
The respondent also denied the illegal business application. Some dependency in the case. These are factors that I have.
It's all general denials. You will deny, no. You will file your count as,
Based on the available document, can you take this defense? I have taken the defense, you are not a dependent. Then if they have produced some document, then it is duty bound on the insurance company to say something. They are not producing.
that is not a specific denial. You deny everything that is, whatever they say in the affidavit, in a, by way of a written statement, you will say everything denied. It won't amount to a specific denial.
You must pay tariffs. Tariffs of the replacement contract, we have regarding relationship agreement. The respondent is not aware they could deny the relationship of the relevant sector with the district copy. Not to deny that they are dependent and legal heirs of the district.
Any issue is framed by the court in that regard. Court has not framed the issue.
It is not, it's just critical. Technically, we have taken the conditions for.
There are no grounds, none of the, no issue. If you see, there is no such issue.
But even otherwise not as per this. As a president, instead of 25%, because They are saying that they will go now, 1% is the satellite. 3% of the income expected and the compensation.
That is also the people.
You will take 4,500. What is the age? 30 years. 37.
The age is. This was 30 years.
Didn't really,
7.
It contribute, it will be 3,150. 4,500, future prospects at 40%, 1,800. 50% of it is 3,150 into 12. What is the multiplier? What is the, is it 34 or 33? 70 is a multiplier. It comes to 6,42,600. What about the other heads?
this is the last of the statement. That is the.
No, there are no heads. What about the
Implement.
children? 33,000. It comes to 6,85,600. Agreed with the award passed by MVC number 5 of 2011. Dated from here. Dated 30th December 2011. How much delay? Let's see. When was the appeal dismissed against insurance company? Was a dismissal order? 211. So we will record that during that time you will not be entitled for any interest. Award passed in MVC number 5 of 2011. Date 30th December 2011. The payments of preferred this appeal. The claim petition was filed seeking compensation of an amount of rupees 1,65,000. The claimants are two brothers and sisters of the deceased who are aged about 32 years, 35 years, and 26 years. It is the case that on 12/8/2008 at about 8:30 p.m. that the deceased was moving near Abhaya Hospital, opposite to early residence, Wilson Garden, Bangalore. At the time, the respondent number one, the driver of the motorcycle, came in a rash and negligent manner at high speed and dashed through the deceased. As a result, he suffered fatal injuries and died while he was being taken to the hospital. According to the claimants, he was earning rupees 10,000 per month. 10,000 per month by working as a security person. It is the case of the claimant that the second claimant, who is the brother, is suffering with paralysis and is not in a position to work. Petitioner number 3 is the unmarried sister of the deceased. And petitioner number 1, appellant number 1, is the unemployed. And all of them are dependents on are depending on the income of the deceased. The insurance company had filed their return statement denying the relationship, income, manner of action. The court below, basing on the evidence on record, had held that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. Then when it comes to the compensation, though it is stated that is earning 15. No, if you look at the claim petition, they said only 10,000. Court has recorded.
Number 2, yeah.
The court below, as there was no evidence placed before the court, had considered the income at 3,500. Had considered the income at 3,000. When it comes to the compensation, the court below, considering the judgments of the Honorable Apex Court and this court, said that the appellants are not dependents upon are dependents on the they are not the dependents on the deceased. They are not entitled for the loss of income. They are not entitled for they are only entitled for the loss of estate. There is no loss of dependency. Accordingly, considering the income at 3,000, has granted an amount of rupees 1,35,000 towards loss of estate, towards transportation 15,000, towards funeral expenses 10,000. Altogether, a compensation of 1,60,000 is granted. Agreed thereby, the claimant is before this court. This court, not this court, on 27/8/2015, this court passed an order granting a week's time to take steps in respect of respondent number 2, that is the insurance company, failing which the appeal against the respondent shall stand dismissed without reference to the court. As the claimant, as the appellants failed to take steps, the appeal against R2 was dismissed. Later, they filed a petition on 2/11/2017 for recalling the said order. On 9/10/2023, as this is an appeal of 2012, this court had recalled the order dated 27/8/2015 and directed Sir Shivana Gowda to take notice on behalf of respondent number 2 and posted the matter today for hearing. The Case of the claimants is that that they are brother and the sister of the deceased. First petitioner, first claimant is unemployed, second claimant is handicapped, and third claimant is unmarried, and all of them are depending upon the income of the on the income of the deceased. Then counsel for the appellant claimant submits that the court below, without considering all these aspects, has failed to grant the compensation at the head of loss of dependency. He submitted that the granting of an amount of rupees 1,60,000 was on the lower side. Apart from that, considering when it is a case that is earning an amount of rupees 10,000, court below ought not to have taken 3,000 as the income. Next paragraph. Learned counsel appearing for the insurance company submits that they are not entitled at the head of loss of dependency, as they are not depending on the deceased. If it is their case that they are depending, they should have placed necessary material before the court, and the burden lies on them. He submits that as they could not place the evidence in support of their contention, the tribunal had rightly granted only the loss of estate as they were entitled for the same. He submits that as far as the salary is concerned, though it is stated that he is earning an amount of rupees 10,000, no evidence is placed for the court. And the court below had rightly taken the income at 3,000, and no grounds are made for enhancement of the compensation. The next paragraph, having heard the learned counsels on either side, there is entire material on the floor. First, coming to the income of the deceased, according to them, he was working as a, according to the claimant, he was working as a security guard and earning an amount of rupees 10,000. No evidence is placed by the claimants in support of the same. Hence, his court is inclined to take, by applying the ratio in Ramchandra Pass case, the court is inclined to take 4,500 as the income. Then coming to the issue of the dependency, the second, according to them, the second appellant, the second claimant is a handicapped person, and the third claimant is an unmarried sister. It is the contention of the insurance, the counsel for the insurance company, that they should have, in support of their case, they should have adduced the evidence. The court below, in that regard, has not framed any issue. And as such, as such, those issues, without there being any issue, without framing the issue, the court below had come to had given a finding that they are entitled only for the loss of estate. The court failed to consider their case, that their dependence upon the deceased, considering the facts and circumstances of this case, where the second claimant is handicapped and the third claimant is unmarried. This court is inclined to take 50% of the income towards loss of estate. As this court is taking 4,500 as an income, and the age of the deceased was 34, 30 years, 40% future prospects would come to 1,800. That is 6,300. If 50% of the same is deducted, it would be 3,150 into 12 and the relevant multiplier is 17. The loss of estate come to 6,42,600 towards funeral expenses is entitled for an amount of rupees. They are entitled for an amount of rupees 33,000. In the light of the law laid down in make allowance so and so. They are entitled for legal expenses at 10,000 altogether. The claimant is entitled for an amount of 6,85,600. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,65,000 to 6,85,600. The appeal against insurance company was dismissed on 27/8/2015, and he filed the application to restore the application to recall the order on 2/11/2017. For the said period, the claimant will not be entitled for the interest. Next, the enhanced amount would carry 6% interest. The learned counsel permitted to counsel for the insurance company is permitted to file the wakalat within 1 week from today. Next. I think the list is also with you. So 1 minute. You see, MFA 9967. Non-filing of LR application. Appellate. When was this filed? Please. 3/26. Last one. 3/26. How much is the delay? What do you say? You will not say, we will say that because there is delay on his part in taking steps. If appellant is claimant is appellant, they will not be entitled for any interest during that period. That will also. No, that is true. They want enhancement. Huh? How? No, that we will decide on the merits of it. Now, as far as the interlocutory applications are concerned, you will not be entitled. That order will be passed. On that condition, these applications will be allowed. No, don't have to argue on that. I understand what he is saying and you are also submitting. Now let's see the LRs have to be brought on record. We'll post this matter on Friday. Why? Then we'll post this on the reopening day. Post this matter on the reopening day. No, that day we'll allow it and within give you another 4-5 days time and here's the application. No, to ensure that you file an application is posted to today. Huh? Anyhow, next matter.
Number 4, recording nothing. Bill number 4.
KV Nayak name is also there.
KV Nayak. Bill number 4.
Who is R3? No, in the MFA, there are only 2 respondents. When is the question of notice to R3? No representation on behalf of the appellant. Pose this matter for discussion tomorrow.
Number 5, hearing on interlocutory application.
In this case, I appear for the second respondent.
Hmm.
They have not served the copies. Nothing
On
is.
you? There is no, then counsel for the respondent, there is no representation on behalf of the appellant. Then counsel for the respondent is present. They submitted that so far they have not served the copy of the appeal memo on the counsel. Pose this matter for discussion tomorrow.
Resolution. Suresh Thakur.
Fine. Huh? What for what? Not able to understand what you are submitting. Use the mic. R2 is to insurance company. Who appears in item in 6 MFA 6220? Pose this matter on the reopening day. By the time the application or it is submitted that the appeal is dismissed against R2 on 10/7/2015. Till now you don't take step. Now you want time. Why you don't know? Pose this matter on the reopening day. By the time that the appropriate application is not filed, appeal will be heard on the merits. Yes.
Number 7.
I appear for the appellant, my lord. This appeal is by the claimant for enhancement. The insurance company also preferred award against the same MFA against the same award in MFA number 10,485 of 2012, my lord.
Hmm.
And the in the said matter, when it came before the honorable court, this the current appeal also ordered to be listed together. May I request your lordship to kindly list the matters together, my lord.
Yes, take that number. MFA,
10,485 of 2012, my lord.
post along with it tomorrow.
Oblige.
Number 8.
Then counsel for
In
the
this,
appellant
I appear for respondent number 2, my lord.
also list along with it tomorrow. Yes.
Right.
My lord, I haven't received a MFA copy appeal memo, my lord. Kindly direct them to serve a copy, my lord.
Why you were directed by the court to take notice?
Yes, my lord, I'm for the insurance company. I have taken
When
notice.
was it? When was that order?
On 18/1, my lord, I appeared for insurance company, call for LCR and take notice was given. I haven't received a copy, my lord.
No, you filed wakalat. You received the notice and
I
filed wakalat.
filed my wakalat, my lord.
No, what is the procedure here, Mr. Krishna Swami? What is the procedure now in all these MFAs and all? Once the appeal is filed, for the insurance company, they will send a notice. The insurance council will file a wakalat, and they have to take the papers from the registry, or they have to, appellant has to serve. Hmm. Yes, because that they would be sending along with the notice, copy of the grounds and all. Yes, anyhow, whatever you want to do post this matter on Friday.
Please, my lord.
Yes, next.
Judgment, civil number 9. Paresh Kumar L.
My lord, I appear for the appellant, my lord, respondent. My lord remembers, it appears the appellant counsel is no more. Court notice may have to go, my lord. Day before yesterday when it was.
If the name was directly printed, why it is not printed? Okay, what happened? Why you cannot get in time? Wherever tomorrow the matters are posted, they have to take the signature on the bench. So then the question of not getting will not arise. Anything is posted to tomorrow, on the bench itself, they have to take the signature. So this court had directed the registry to print the name of Muniappa. What is the name? Muniappa. The name is not printed. Post this matter tomorrow, print the name of the.
May I request, my lord, day after, immediately after vacation, I have some inconvenience. My lord. Immediately after vacation.
Matter after vacation.
Oblige.
Number 10. Please, after
Yes. Oh, this is a matter about estate, loss of estate dependent. What is the citation tell here? Awesome. From the order. Yes, we will just read this quarter. Para 14, 22, 23, 23.
Tell that what the practice recommendation of the appellant. I have a daughter, no longer dependent on what we have known. What is the order of the but how old she be? The dependency is relevant does not mean financial dependency, but dependency to value of service. But it can never be equated in terms of.
So para number 22 is about filing the application under 166, though you are not a dependent. There is no dispute on that. That can be filed. Then let's read 23.
Married sons are entitled.
Entitled for compensation. That is also, yes, they are entitled for, no, two issues there. You're mixing up. They can file a petition, number one. Number two, they're entitled for compensation. Under what head is the question? Loss of dependency or loss of estate?
Yes.
Which one you're reading? On the apex code, please read. No, read 23, the whole para.
Married. The contention that married daughters of the not entitled for compensation cannot be accepted. The court has taken note of the act and again coming married sons, major sons are really again compensation. Married daughter also entitled for compensation on all the days. Not only he.
Give that judgment to the senior counsel. Copy of it, give it to him. Read para 24. 24 of the judgment. Very broad interpretation. Twenty-four. No, are you reading 24? Para 24? Yes.
Bond between mother and daughter is further observed that even if the dependency is relevant, between the article of dependency, it does not mean financial dependency. It is the covenant. Dependency includes graduous services, dependency, physical dependency, psychological dependency, so on and so forth, which can never be equated in terms of therefore not that money. For irrational position is proportioning things.
No, however, dependency is defined. That's what is the interpretation by the court.
What is the emotion?
No, then read what is this is consideration. And what is the ratio? This court's judgment.
Considering the principles laid down in the judgments referred to this court has taken note of recent judgment of the upper court in varying that. Which I have ready. Wherein it held that even married sons are taken for compensation not only on conventional heads, but also on cause of dependency. Hence, the very contention of the other insurance cannot be accepted. During the case of 15, they were getting, they were foolish.
No, let us read. You are skipping to 158.
68.
Give the book. There's more different. Yes.
inquiring the or as the case may be, each of the client is subject to the provisions of section 163. Here, they can avoid determining the amount of compensation which appears to be inherent. And specifying the
No.
compensation to be paid in making the award that the amount which can be paid by the insurer or payers before the next or any of them. The case may be. This is what
No, in Pranay Sethi and Sarla Verma, this loss of dependency must have been discussed at length. So let us look at what it was discussed about dependency. That is where the whole calculation started. Did they specify that loss of dependency means this is how it is? Get a judgment of Pranay Sethi. That's there in the loose paper judgments. It's there. Index, I don't think you'll find in that.
people tell that not married, but he can take it and
we were employed depends on
In any of the judgments, this issue fell for consideration about what is the dependency in terms of the MV Act.
all of the complicated in terms of money. Then what is the yardstick that will be avoided with that? One, ladies face it as a separately decided. This lady is who is emotional attachment.
Apart from the emotional attachment, whatever their income that they are deriving, or from whatever they are doing and all, no, she will not have her everything to herself. She will contribute it to the children. In a system like our kind of a society and our kind of a system, family system.
Is the same. That would be the last mistake. That
The real sense is lady was not a dependent. What people be dependent. Compensation will be granted. Compensation means recompense them. Recompensing the respect of dependence.
In this case, this is the
Mother.
mother is the
This
deceased
is the mother.
sole claimant. I think all the more reason this court, this case is, she's entitled. Because mother and daughter, definitely she will, whatever she's earning, she will definitely, give the judgment, Virendra. It is here. What is that?
2010. Yeah, right. Yeah, this is
Hmm.
immediate. But the reason why I want to do that is compensation.
No, 15, no, 15 if you read before that, let's complete this. It says, it is thus settled by now that the legal representatives of the deceased have a right to apply for compensation. Having said that, it must necessarily follow that even the major married and earning sons of the deceased, being legal representatives, have a right to apply for compensation, and it would be the bounden duty of the tribunal to consider the application irrespective of the fact whether the concerned legal representative was fully dependent on the deceased and not to limit the claim towards conventional heads only. The evidence on record in the present case would suggest that the claimants were working as agricultural laborers on contractual basis and were earning meager income of rupees 1 lakh and rupees 1,50,000 per annum. In that sense, they were largely dependent on the earning of their mother and in fact were staying with her, who met with an accident at the age of 48 years. Then the court before that para, what was discussed? Inclusion, character, scope about the two CPC amendment.
It's a concept. Once again, I read 168.
What are the other judgments apart from this, Virendra? Manchari, where? Where is? Then how to calculate that loss of the income? How much has to be deducted?
People fight like. You cannot take all the five as dependents. Yeah, just compensation is appears in just persons to whom compensation will be paid. Because why only one person is entitled.
So why can't,
Compensation is paid.
no, if in the other case, how it is decided? Why can't we take 50%? Why can't we deduct 50% towards the personal expenses and remaining 50% as consider it as the law as loss of estate and calculate it? Because whatever she's earning, 50% she would have for herself. Where was the, what is, let us see that. Yeah. So as on that day, she's working, and she's working as a where is that? Let's see. It's a government. Do the lower court record. Column number, amount of compensation. 15,200 is her salary. Yeah. Page number 3. Oh, it is submitted that. I mean, cross-examination did say enough. What are the questions put forth to her?
ನಾನು ಬಳಿಕೆ ಬಂದಿಲ್ಲ ಆದರೆ ಅಡಿಗೆ ಅದನ್ನು ನನಗೆ ಮಾರ್ಕ್ಸ್ 50 ನಾನು ಬೆಳೆಯಾಗಿದ್ದು ನನ್ನ ಜೀವನಕ್ಕೆ ನನ್ನ ಗಂಡನನ್ನೇ ಅವಲಂಬಿಸಿದ್ದೇನೆ. ನಾನು ಕೇವಲ ನನ್ನ ಜೀವನಕ್ಕೆ ಕೇವಲ ನನ್ನ ಗಂಡನನ್ನು ಅವಲಂಬಿಸಿದ್ದೇನೆ ನಿಜ. ಆದರೆ ನಾನು ಈಗ ತಾಯಿಯ ಮನೆಯಲ್ಲೇ ಇರುತ್ತೇನೆ. ನನ್ನ ತಾಯಿ ವಿಚಾರವಾಗದಲ್ಲಿ ಸಂದೇಶವಾಗಿ ಅವರಿಂದಾಗಿ ಅಪರಾಧವಾದ ಕಾರಣ
And what is the common substance of fraud?
loss of dependency.
So now loss of estate, how do we calculate? That's what I'm saying. No, her income is, that's why, no, she is 50,000 is her salary. 15,000 is her salary. No, half of it, 7,500. Oh, she would spend for herself. So 7,500, because it's an accident of 2011 or 10. So 7,500 is a good decent amount. So for one single lady, she'll have 7,500. So remaining 7,500.
Replace that.
Because she has a only daughter. All the more reason. Her. Out of 15,000. 7,500.
9,500. You have also spent for other.
What the food bill had taken? One third of total salary. It comes to 5,000. It will be 11,000.
Right.
So instead of that 11,500, whatever the quote had taken, take 7,500. 7,500. $7,500 into 12 into what is the multiplier? 9. It comes to 8,10,000. Now, in that, you are liable to pay 80% into 80 is 6,48,000. Consortium 44, 33,000. General expenses. comes to 7,25,000. How much is granted by the court below? 7 lakhs? You'll be paying 7,25,000. Your appeal is partly allowed. Please come. Yes. This is an appeal filed by the aggrieved by the award passed in MVC number 89 of 2011 dated 31st March 2012. Both the insurance company as well as the claimants have preferred the appeal. Insurance company's appeal is numbered as MFA 677 of 2012. The appeal of the claimant is numbered as MFA 6766.
No, yeah, that means. When you have not heard any appeal, insurance company has heard any appeal. But then the owner of the other vehicle has made a
Appeal filed with the owner of the vehicle is numbered as MFA 6776 of 2012, and the appeal of the insurance company is numbered as MFA number 1469 of 2012. The claim petition is filed stating that the deceased is the mother of the claimant who was aged about 59 years, working as a FDC in Banur municipality. The monthly of rupees, the salary of rupees 15,000 was a pillion rider on a TVS moped, which was ridden with the first respondent, who was Srirangapatna from Mysore side. At about 11:15 a.m. on 18/2/2010, when the first respondent hit the said vehicle, the deceased and the first respondent and the third respondent fell down and sustained injuries. The mother of the claimant has become unconscious, and when she was shifted to Columbia Asia Hospital, wherein she died after 2 days. There's a case of the claimant that she's married and staying along with her husband at Hassan. Is it so? Hassan?
Yes, sir.
Staying along with her husband at Hassan. And as she lost her mother, which is an irreparable loss to her. According to the insurance company, accident had taken place because of the negligence on the part of the driver of the TVS moped. Now, deceased is a pillion rider. Then where is the question of contributory negligence? Who's the rider of the vehicle? Rider of the vehicle.
The other vehicle, the vehicle, south of proceeding in the direction where the wheels is
No, the insurance company has insured the moped. Hmm. Correct, that is in respect of the driver. What is the case of a pillion rider? Deceased was a pillion rider.
This is the clear right.
Hmm. And the insurer of the moped is there.
They are not going to see.
No. No, that contributory negligence will hold good in respect of the when it is considered about the rider of the moped and rider of the offending vehicle. Then correct. Then what about the pillion rider? In case of pillion rider, how it should be apportioned? Oh, in this case, 100% compensation, 50% composite negligence by both the drivers of both the vehicles. So for fixed 50% on 50% on. Yes. But therefore the contrary about for negligence, it was heard last again. What did you write? What is that?
According to the
Driver of the offending vehicle, not the previous mover. Of the offending vehicle. The court below on the issue of negligence has held that on perusal of exhibit P3, P4, Spot Mahajan and Strike, the accident occurred in the northeastern corner of the circle where the first respondent had crossed almost 80% of the circle. And the meanwhile, third respondent also entered the circle. Thereby, motorcycle hit to the first respondent. Therefore, the defense taken by the first respondent is probable that after he entered the circle, the red signal was on to him. Therefore, there was no other course except to proceed. Therefore, it appears that he proceeded instead of stopping his vehicle in the circle, causing nuisance and inconvenience to the other vehicles. He stopped. He made an attempt to enter further, to enter into Srirangapatna Road. If the third respondent was alert and slowed down on seeing the first respondent, who is almost in the end of the circle, first respondent is the rider of the moped. Accident would not have occurred. A case was registered against the first respondent and charge sheet is filed against him. Accordingly, the court has held that there is a negligence on the part of the drivers of both the moped, riders of the moped as well as the offending vehicle, and apportioned the same at where will you get that? Apportion the same at 50% on both the driver of the moped and on the rider of the offending vehicle. Last occasion, the court said 80 and 20%. Then counsel and the court had granted compensation of an amount of rupees 7,42,588. Considering the loss of dependency at 6,88,000.
ಹಂಗೆ ಮಾಡಿದ್ರೆ ಸುಲಭ ಅಂತ.
That is not added.
ಅವಳ ಮನೆಗೆ
ಆಯ್ತು.
No, medical.
You didn't ask him, ಕೇಳ್ಬೇಕು.
8,10,000. Funeral expenses were not, this medical expenses were not 39,400. Come to 314, 8,49,400. 8,49,400 into 80 divided by 100 is 6,79,520. 79,520 plus 44 and 33. 33 and 10,000 legal expenses were not added. Comes to now 7,66,520. Tell the then council. Loss of estate, consortium, funeral expenses, legal expense. What is that? What did you write? Court has granted to a loss of dependencies like 88 that you written. Medical expenses 39,000, funeral and obsequious expenses 5,000, loss of estate 10,000. Altogether, granted compensation of an amount of rupees 3 lakh, granted 7,42,588 as the contributory negligence was fixed at 50%. Now, I think not the calculation. No, your 20% is there. Your 20% is there. So, it would not vary. Now, 8,10,000. And legal expenses, you are not entitled. No, the whole amount would be, I was like, as if it is claimant, I was doing the calculation. Plus 39,400 plus 44. 54,000 plus 33,000. It comes to 9,26,400. In that, into 80 divided by 100 is 7,41,000 120. You are liable to pay 1,85,288. That's the calculation. I'm putting 7,500. Our age was? Our age was? 59 is the future prospects would be 10%. You have to assess the court. If the court is forbidding any of the heads, you should tell the court. It comes to 750. Or it would be 8,250. $8,250 into 12 into 9 is 8,91,000. It comes to 8,91,000. It comes to 10,07,000. No, the insurance company has to pay 8 lakh. At 5,500. Yes, 6,588. In that, the owner and insurer of the moped was directed to pay an amount of 50,000, 50% was contributed negligence, and owner of the offending vehicle. That is, what is the make of the vehicle? What is that vehicle? 50%.
Yeah.
So that is 3,71,294. The aggrieved thereby both the owner of the vehicle as well as owner of the Suzuki vehicle, that is the third respondent in the before the third respondent before the MSCT, and the insurer of the moped are before this court. Land counsel appearing for the for the insurance company submits that the extra, even the court below has observed that the driver of the moped had crossed almost 80% of the circle, and in the meanwhile, third respondent entered the circle. Thereby, his motorcycle picked to the first respondent's motorcycle, which clearly shows that there is negligence on the part of the driver of the offending vehicle. The court below, basing on the police records that the charge sheet is filed, that a crime is registered against the owner of the moped, and held that there is a contributory negligence on the part of the driver of the moped, which is insured by them. He submits that the negligence, if the rider of the Suzuki had not entered, had stopped this vehicle, even as per the evidence, the driver of the moped has crossed 80% of the circle, the accident would have not happened. It is submitted that there is no negligence on the part of the rider of the moped, not the driver, rider of the moped. On the issue of the compensation, the court below had considered the evidence. As per the evidence, the deceased was working as a FTC in Banur municipality and earning a salary of 15,000 and the head of loss of dependency. Court had taken, how much is considered? 8,000 or 11,000? By considering the dependent as one, deducted 1/3 and towards personal expenses, and the contribution to the family was taken as 11,469, and by applying the why this 5,735? Court had taken 5,735 as a salary and into 12 and the multiplier 8 granted an amount of 5,50,560. And as she has only 1 year, loss of dependency for the first year is considered as 11,469 into 12 into 1. That is 1,37,628 altogether. And the head of loss of dependency, an amount of rupees 6,88,188 was granted. It was medical expenses, an amount of rupees 39,400. And funeral and obsequies 5,000. And loss of the estate 10,000. Then council submits that the daughter is staying. Daughter cannot be termed as a dependent. She's staying. She is leading her independent life. Her husband is gainfully employed. At any stretch, it cannot be said that the daughter is a dependent. Land Council has drawn the attention of the court to the evidence and the amendments in the claim petition and submits that the amendments in the claim petition and submits that the submits that she is not dependent and he has relied on the judgment of the apex court. What is this? Manjari Behra. In the judgment of the apex court, in case of Manjari Behra, he submits that even in Birendra's case also, basing on the facts and circumstances of the said case, where all the claimants or laborers are earning meager amounts, had granted the compensation. Now, in this case, claimant is not before the court. You are for the claimant. He is for the owner of the vehicle.
Facing the facts and circumstances. All the claimants are laborer earning on
Meager amount and granted the compensation. He submits that the person who is not a dependent is not entitled for any compensation under the head of loss of dependency. They are only entitled under the head of loss of estate. The next paragraph, Land Council appearing for the owner of the vehicle submits that even as per the evidence on record, the rough sketch and other evidence, it is clear that when the signal light was on, when the red signal was on, the rider of the motorbike has jumped the signal and cross a circle. After the rider of the Suzuki, after the green light, he started and it cannot be said that there is negligence on the part of the rider of the Suzuki. There is no contributory negligence on the part of the rider of the Suzuki. As per the police record and as per the evidence, it is the driver of the moped who is alone liable to pay the compensation. Who is alone liable for because of whose negligence the accident has happened. This court has perused the evidence on record. Okay. Then counsel appearing for the claimant submits that She is the only daughter of the deceased, and she was earning an amount of rupees 15,000 per month. Per month, as she is the only daughter, she would be contributing the amounts for her. He had relied on the judgment of this court in Reliance General Insurance Company Limited versus Gangappa in MFA number 102868 of 2014, and submits that this court, considering the judgments of various high court, and further the judgment of Virendra's case, held that the even married sons are entitled for compensation, not only on conventional heads, but also on loss of dependency. He submits that the court below ought to have considered the loss of dependency. He submits that the amount that was granted by the tribunal was not reasonable. Next paragraph. Having heard the counsels on either side, there is entire material on record. First, coming to the negligence part. As per the evidence, the rider of the TVS motor jumped the signal, and while he was crossing the circle, the accident had taken place. It clearly shows that there is a clear negligence on the part of the rider. At the same time, had the rider of the Suzuki has taken proper care, and looking at the vehicle, as he stopped the vehicle, the accident did not happen. Hence, considering the manner in which the accident had taken place, this court is inclined to inclined to apportion the negligence at 80% on the driver of the moped and 20% on the 80% on the rider of the moped and 20% on the rider of the Suzuki. Then coming to the compensation, then counsel appearing for the insurance company submits that the married daughter who is not dependent upon the deceased is not entitled for any amount under the head of loss of dependency, but she is only entitled for the loss of estate. This court has referred supra the judgments relied on by both the counsels, that is, the judgment of the apex court in what is that, Manjari Bera's case, and also in case of Birender, and the land council has relied on the judgment of this court. Admittedly, in this case, the claimant is the only daughter of the deceased. She is earning 15,000 per month as salary, even if, as in case of a bachelor, or that if 50% of the amount is deducted towards her personal expenses, it comes to 7,500. The 10% future prospects will be 8,250 into 12, and the relevant multiplier 9, it comes to 8,91,000. Loss of estate, hence the claimant is entitled for an amount of rupees 8,91,000 towards the loss of estate. Then towards medical expenses, that Mr. Krishnaswamy, court has granted medical expenses of 39,400. That was not absorbed by the court. 39,400, consortium 44,000, and towards funeral expenses 33,000. It comes to 10,07,000. 80% of it, as this court has apportioned the negligence on the rider of the moped at 80%. The owner and insurer of the moped are jointly and severally liable to pay an amount of rupees 8,05,600. And the the and the owner of the Suzuki has to pay an amount of rupees 2,01,400. Accordingly, the appeal of the insurance company is dismissed because now the contributing negligence has increased, compensation is decreased.
Is.
Insurance company's appeal is partly allowed, holding that the liability, the negligence at 80% and 20%. Insurance company shall pay 8,05,600 and the claimant at 2,01,400. And the owner of the Suzuki. The awarded amount will be 6,000. Yes.
Appears for the appellant.
Yes.
It is for dictation. Yesterday, your lordship heard me.
No. My other side was not there.
Yesterday, no one was there.
I think the calculation was also done. No. No, except the injured, no other person was examined on their behalf.
My lord, RW3, my lord, I read out the.
Not on their behalf, on behalf of the claimant.
On behalf of the claimant, my lord, only PW1, my lord, Vasha, who not an eyewitness, my lord, has been examined. And the father of the, my lord, the deceased. And he also stated that he was informed by the police after 4 days. Evidence of PW1.
Give that evidence also. Your court record.
PW1 is the father of the deceased. In the cross-examination at typed page 4, I have not seen the accident. I have seen the spot of accident. There is no bus stop near the spot of accident. There is a signal. Police informed me about the accident after 4 days of the accident. Then RW3, my lord, evidence of RW3. He says, I can't say on what basis the charge sheet was filed on this case. RW1 is the driver of BMTC bus. R2 is the conductor. That evidence had not been believed by the tribunal. But so far as RW3 is concerned, without proper discussion, not it.
Date of accident,
Date of accident, my lord, is 23/10/2010 at 11:45 PM according to the claimants.
Hmm. Hmm. When was the complaint given to the police?
Exhibit P1, my lord,
Dated
is on 24/11.
20?
24/11/2010.
That is after a month.
After 1 day, my lord, after 1 day.
Accident is on 23/11.
23/11. Complaint, my lord, is by.
On that day, they have mentioned the number of the car, number of the bus in the complaint.
In the complaint, my lord, let me kindly turn to my lord the exhibit P1.
Complainant is the police officer.
Yes. May I read, my lord, the IHV Shivana ASI serving in Upparpet Traffic Police Station submit my report as hereunder. On 23/11/2010, I was appointed on patrolling work in the station jurisdiction from 10 PM to 8 AM. Accordingly, I was on duty. At about 11:15 PM, I received a message from the controlling room that a pedestrian met with the road traffic accident at Sagar Junction, Kempegowda Road, and I was asked to check in this regard. I immediately went to the spot. One chitta of Upparpet police station was there. When I inquired him, he informed me that some vehicle had dashed to an unknown pedestrian stranger. The said pedestrian had sustained injury to his left waist portion and he is taken to the Victoria Hospital in Vaisala for treatment. This is the FIR.
He was examined.
Pardon?
He was examined as a witness.
RW3, my lord. RW3. I'll read once again, my lord. I am working as ASI at Upparpet Traffic Police Station from June 2006 to till December 2011. I was on duty in the said police station on 23/11/2010. I have received information from control room that the accident has taken place near Sagar Theatre. I went to the spot of the accident and inquired with the police constable present near the spot of accident. He told me that one accident has taken place and injured was taken to Victoria Hospital in Vaisala vehicle. I have not received information with regard to the vehicle which caused the accident. When I went to place to the spot of accident, signal was not working. Usual signal will be closed at 10 PM. I cannot say on what basis charge sheet was filed in this case.
Charge sheet was also marked.
Pardon?
Charge sheet was also marked. Charge sheet was marked.
Charge sheet has been marked, my lord. Exhibit, my lord. Exhibit P2, my lord.
Please read for that relevant portion. What do they say about how they found that this vehicle is involved?
Yeah, my lord, how they, my lord, that's why, my lord, I read out, my lord, the evidence of, my lord, RW3. He was informed
Is
that.
that how the charge sheet is filed? He doesn't know because he didn't see the vehicle. And
Well,
by
he
10
said-
o'clock, the traffic signals will be off.
My lord, he says, I can't say on what basis charge sheet was filed in this case. Vehicle number is not known, unknown vehicle, unknown person.
Let's see from the charge sheet, what was it? What was, how they found out the vehicle?
Yeah, charge sheet, my lord. In the charge sheet, my lord, they mentioned the vehicle number. And the name of the driver, my lord, is shown as Ramesh. This charge sheet do not assume any importance in the light of, my lord, evidence of RW3, the inspector who submitted the charge sheet to the jurisdictional magistrate. Charge sheet, my lord, is of 1 of 2011. Filed, my lord, on 7/1/2011.
Hmm.
That is after 3 months of the, my lord, and my respectful submission, my lord, evidence of RW3, my lord, clinches the issue. On what basis this vehicle, my lord, how they found out?
Correct, I heard you. Like, I want to know what is there in the charge sheet. What did they say about how they found that this vehicle and their investigation
No,
revealed
my
that?
lord, they don't say anything. They simply say, my lord, that this vehicle was involved at about on 23/11/2010 at about 10:45 p.m. Accused in the column number so and so was the driver of the bus, and he drove the same in a rash and negligent manner. When RW3, my lord, the inspector who has lied them, my lord, the charge sheet, he himself says that I don't know, I can't say on what basis the charge sheet is filed in this case. And the constable who was at the spot, my lord, he says that an unknown vehicle, unknown person.
Agreed with award passed on MSC number 181 of 2011. Dated 8 of June 2012. The insurance company is before this court. The claim petition is filed in compensation of an amount of rupees 15 lakh by the claimant for the death of the deceased in the road traffic accident. The case of the claimant is that on 23/11/2010, for 10:45, the deceased was traveling in PMTC bus. The driver of the bus drove the same in a rash and negligent manner and stopped the bus at Sarkar Junction. The deceased was aligning from the bus. The driver of the bus moved the same in a rash and negligent manner. Due to the impact, distance went down and sustained head injuries. Immediately after the accident, deceased was shifted to Victoria Hospital, wherein he was declared dead. The court below on the issue of negligence, considering the evidence of VW1 and that the complaint is given by the police officer, who was on the patrolling duty. Unmute your audio.
Go ahead, sir.
RW3 says, my lord, that on receiving a message from the control room, I went to the spot. The police constable who was present informed me that an unknown vehicle had caused accident to an unknown person. And the person injured was taken to the Victoria Hospital by Vaisala. That's all.
Complaint is given by RW3.
RW3.
The police officer, RW3, has given the complaint. And the charge sheet is also filed against the driver of the BMTC bus, and accordingly, court has held that the accident had taken place because of the negligence on the part of the driver of the BMTC, and they are liable to pay compensation. Granted compensation of an amount of rupees
6,26,000.
this court, this matter came up before the court on 10/10/2023. There was no representation on behalf of the respondent. This court has heard the learned counsel for the appellant, and posted the matter for judgment today. Today also there is no representation on behalf of the learned counsel for the respondent, as this is an appeal of petty level. The court is inclined to proceed the matter basing on the material available on record. In support of their case, the claimants have examined
PW1, my lord, father of the deceased.
PW1. Claimants have examined PW1, the father of the deceased, who is not an eyewitness. On behalf of the respondents, RW1 is the driver.
RW1, my lord, is the driver, Ramesh.
RW2 is a conductor,
Yes.
and RW3 is the officer who has given the complaint.
And filed the charge sheet.
Complaint and who filed the charge sheet. Except examining PW1, no, before that, and marked exhibit P1 to P12. Exhibit P1 is the first information report, P2 is a charge sheet, P3 Panchanama, P4 postmortem report, P6 inquest Panchanama, P5 inquest Panchanama, P6 fetch, P7 IMV report, P8 notice under section 133 of the MV Act. Exhibit P9 is a certified copy of the report. P10 is a certified copy of the thrift sheet. Exhibit P11 is a salary certificate. Exhibit P12 is a notarized copy of the election ID card. And P13 is a birth certificate. And the exhibit P4 is a notarized copy of the election ID of the claimant number 3. The claimants, when they have come before the court filing an application under 166, they have to produce the necessary evidence to prove their case. Once they discharge their burden, the burden shifts to the insurance company. It is a case that as the deceased was traveling in a BMTC bus, because of the negligence on the part of the driver who drove the same in a rash and negligent manner, the accident has, when he was about to get down from the bus, as he has taken the bus, he has sustained the injury. The court below had relied more upon the complaint given by RW3. And considering the charge sheet file, the court has come to the conclusion that there is negligence on the part of the driver of the BMTC bus. This court has perused the evidence of RW1, RW2, and RW3. RW3 states that as he was on a duty in the night time, he received a call from the constable, and when he went to the place, constable has informed him that an accident had taken place by an unknown vehicle, and the injured was taken to which hospital?
Victoria Hospital, Malad by Vaisada.
Was taken to Victoria Hospital. He has stated that he has not seen the vehicle, and even in the complaint also they have stated that the vehicle is an unknown vehicle. A vehicle is an unknown vehicle. It is also deposed by RW3 that on what basis the charge sheet is filed is not known, because they were not aware of the bus which is involved in the accident. It is also stated that the accident had taken place at what time? 10? Mr. Mahesh, at 11:40 p.m. Accident had taken place at 11:40 p.m. And the signal lights would be switched off, would be off by 10 o'clock. So on record, there is no evidence to show that the bus of the BMTC is involved in the accident. The code below, without going into the considering the evidence and without considering the evidence of RW3 and RW1 and 2, which supports the case of the insurance company basing on the charge sheet filed, had come to the conclusion that the driver of the BMTC bus was at fault. In view of the above discussion, particularly in the light of the evidence by RW3, the police officer who have filed the charge sheet and RW1 and RW2, court comes to the conclusion. This court is of the view that the tribunal, the MSCP, has been coming to such conclusion about the involvement of the BMTC. The appeal is accordingly, the appeal of the insurance company is allowed by setting aside the award dated so and so. The amount in deposit shall be forthwith transmitted to the court below. The insurance company is at liberty to withdraw the
Please.
Yes, ma'am. The other matter, earlier matter, the citation, let us keep it in the file. This also. Keep in that file.
Number 12.
Yes. What public place and agriculture purpose and all. It is some other purpose or something. Please pass on. That is India insurance. Let's see.
Also,
Yes. And the other day, about week or so, in the similar line, this court has also passed for an order in your case, where you were arguing about the public place, where it has happened in a internal Kacha road or something, which is way to the fields of, on a banda. It has happened on a banda. Band. No, unfortunately, vehicle is insured and it's for the agriculture purpose. When they are doing the agriculture operations, if something takes place, there is use of vehicle.
That's exactly what's noted in the release of some report.
Operations are required to be covered even. Even requirement is any motor vehicle. Each of them. And that is made of 147. But it's in the public place. We are doing it. I think the basic report collection assumption of wasting that place.
No, a vehicle which you have, the tractor trailer will be used in a field majority time, except for the transit.
It is that it is not exclusively used the private agricultural line. They can also try use public road. That is the reason third party is illegal.
No, that is the provision. So there are several judgments of the Supreme Court where even in premises, in a private premises, when a particular vehicle, a motor vehicle is used, and because of that use and any accident has happened, that was covered. Well, the other day we have looked at the tanker and other cases. I think Sambhaji Shinde or something. No, what has happened is a petrol tanker was parked in the premises, and they have called some welder for the welding work. In the process, something has happened, and he was injured. That was in a private. It is within the premises of that particular.
Just area. Yes.
I think that day we read the definition also. That day we read the definition also. No, last occasion when I passed that order, we have also considered the public place as defined under the Act. Two things. Now let us see that how it is defined under the Act. The other day we have seen that. Two, hmm. One minute. 234. Public place means
Street, way, or other place.
whether a thoroughfare or not. Hmm.
It's the public. Way, or and
It's a inclusive definition.
Yeah. Why in this section? Place meaning. Road. One place.
Area to the other.
Street is. Place. Where.
Now, what is this other place?
Place meaning. It is connected to second person. Place. Whether it's thoroughfare or. So, yeah. Right, yes. You have a right that this is my identity. Yes. And includes any place of spend. Ascendants of, or the down.
We'll post this matter on the reopening day. In the, but that's for the judgment or in which caption? We will have in the same caption on the reopening. Because the senior wants to pay some judgments, we will also see that. It is 20.
so exactly we get some other matters.
Then on 20, 27, 26. Keep these judgments in the file. Yes.
Kindly.
Number 30. For the children, 8 this morning.
Yeah. This is it. No.
Divided in. Yes. Which, however, the institution has come out that there is a growth relating of data. Both reside in the same home.
Hmm. So let us just go to the issue so that the court will understand the fact. Let's read the issue. Yes. LIC office as a peripheral. Now, according to you, this claim, the claimant and respondent number one are living in the same house. Hmm.
Investigate and come to house and take it.
You see, even if you look at the address also, it's different. Respondent number one. The investigator was examined.
Investigate and come to house and.
She has stated that. And she accepts the contents of the. We continue after lunch, Mr. Shubham. We continue after lunch. Take the other signatures.
Kindly of the court.
Yeah.
Kindly of the court. CL number 20, my lord.
Yes.
I appear for the, it may be had after vacation. This is check bones case. I had prepared some notes. Today afternoon, I have to go to a doctor. After vacation, my lord,
Inform the other side.
I'll inform.
The request of non-counsel opponent.
Much of.
Why? You are not well. Item number 17 at the request of non-counsel for the respondent. He says he is not pleased for the respondent. He is not well. Post this matter for after vacation, the same caption. Yes.
ಕಂಟಿನ್ಯೂ ಇದೆ ಇದು ಕಾಂಕ್ರೀಟ್ ಮ್ಯಾಟ್ರ್ ಇಲ್ಲ ಬರೀ ಮೇನ್ ಫ್ರೇಮ್ ಮಾತ್ರ ಇದೆ.
Court officer?
Sir?
Madam, serial number 21 ಇದೆಯಾ?
Number 21.
ಸುಮಂತ್ ಬರದು.
ಇದೆ ಸರ್.
ಇದೆಯಾ ಅಡ್ಜಾನ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಇದೆ.
ಇವಾಗ ಎಷ್ಟು ನಡೀತದೆ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 13 ನಡೀತಾ ಇದೆ ಸರ್.
ಅದರ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ?
ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಇಲ್ಲ ಸರ್.
ಕಂಟಿನ್ಯೂ ಆಗತ್ತಲ್ಲ ಸೇಮ್
ಹೌದು.
ಲಿಸ್ಟ್.
ಹೌದು.
ಓಕೆ.
It's not. Okay. It is 2 o'clock. Okay. So, you can apply. Ready? Yes. Claimants appeal. How much was the compensation claim? How much was granted? 4 lakh? Any disability as per the doctor? How much? How much the court considered? Examined anyone? Here is the accident. Rightly taken. Oh, when you say that this is your income, you have to adduce some evidence. If there is no evidence, court will take the notional income or whatever. And for the year 2009, 2010, court has rightly granted 5,000. On what basis it should be enhanced? No legal services authority. That we will see. That we will see. Please come to the calculation. Come to the calculation judgment. Which para? Para number? No, we will read the discussion on this quantum. Come to para number 12. One more surgery. For having the state hospital charges and for having the purchasing rent. What happens? Even though the same relative, one of experience. So as per the thing, he has spent on that. The doctor has what for integrity. No, that is, you have considered 5,000 that you can find from the table, loss of earnings. It is 5,000 into 1. So towards pain and suffering, a good amount is granted, 80,000. It need not be enhanced. Then medical expenses as per the medical bills. Medical bills, 1,53,000. Now disability, now we will see disability, it is 5,000 into 12. What is the age? Huh? What is the multiplier? 16. Into 16 into 20. Yes. Huh? No, right. Now the court will make a fresh calculation, nothing to be deducted. 5,000 into 12 into 16 into 20. It is 1,92,000. The next step, loss of amenities in life. Correctly. It's so for that year, amounts that are granted are on the higher side. They should have preferred an appeal.
Because disability, some amount was not that.
Future medical expenses as per the doctor. That's also right. Then loss of earning during the later period, that is less. For the injuries, 3 months can be loss of earning. During the later period is 15,000. 5,000 into 3. 15,000. No. No, but still attendant at the kind of a conveyance and transport will grant 10,000 on 3 heads. 10,000
ಹೆಗ್ಡೆ ಮುಳ್ಕೊಂಡಿದ್ದಾರೆ.
Lord, proceedings are muted.
I think this matter came up yesterday. Now, there is no representation for you. The matter is adjourned to today. Yes, what do you think? This is an appeal for enhancement or on the liability also? Only on enhancement. How much was claimed? How much was awarded? Any disability as per the doctor? And how much the court taken? Whole body disability is, I mean, the particular limb. 22 point? No, when total disability is 22.5, I mean, to the limb, how it would be whole body 16%? Court had rightly taken. No. Court had rightly taken 1/3 of it. Yes, no. What was your income? You're a student. Hmm. No legal services. No legal services chat. Which year was the accident? Where is Mr. Punacha?
Punacha for R3? Serial number 16?
Will pose this for judgment tomorrow? Hmm? No, that's what, for judgment tomorrow. He will also be there so that we can pass order. Learn counsel for the appellant present, no representation on behalf of the insurance company, heard in part, post for judgment tomorrow. Yes.
Hearing? Serial number 18?
Huh?
I'm appearing for the respondent, my lord.
Which matter?
Serial number 8, is it 18, my
What is the
lord?
confusion? Morning, somebody made a mention, I think. Not informed. Then who made the, probably some wrong number might have been mentioned. File is there. Just wait, next matter will take, then in the meantime, she will search for the file. Yes, next.
Serial number 18? R41?
My lord, I am appearing for respondent insurance company, my lord.
It is for announcement or it's for enhancement? No. If it is not, if it is on live, no, the liability is also on issue. The whole afternoon, Mr. Venkatesh will take.
He loves only.
Huh? What was the claimed amount? What are the injuries? Simple, what are the injuries? And then why will the court grant 2 lakhs for you? It is damage.
10 page 9.
Now let's see. Please come to the order. Let's read the relevant portion.
Para 10 page 9, my lordship, learned MACT.
Yes. Let him read. Read.
Please.
Since all these issues are interlinked. Para number? No, let me understand the fact. Read from there. Para 10, read. Was examined. No, PW1 on your behalf. Who is PW2? Who is PW1? Yes, Mr. Venkatesh, who is PW1? PW2 is? Court has already granted 50,000 without any evidence. Where is the evidence? That is what the court has observed. Please come. You have a simple injury, 3,000 pain and suffering, and no other material for the court to give any other compensation. This is an appeal filed by them. Huh? 3,000? Simple injury, which is in the year 2010. And you have not placed any medical record. You have not examined anyone. Court without still considering whatever you said to be true, granted 3,000. This is an appeal filed by the claimant. This. Where is evidence? Sure, court is ready to grant. This is an appeal filed by the claimant agreed with the award past time. MBC number 577 of 2009, dated 4th November 2010. The claim petition is that seeking compensation. Huh? He says some consideration to be. Unmute your audio.
Sufficient award is already passed by the learned judge, my
No,
lord.
for the bodily, for the pain and suffering.
My lord, only one exhibit P5, only one simple injury, which is very simple in nature. That is one by noted my learned judge.
Even the simple injury will give some pain.
That I leave it in court, my lord.
How much? How much?
Another 5,000, my lordship. Please.
No, you don't stretch it too far. That's enough. Yes. This is what did you write? Claim petition is by seeking compensation of an amount of 2 lakhs for the bodily injury and damage to the vehicle. The case of the claimant is that on 25/3/2009 at about 4:30 p.m. near Donapura Bridge on NH 13, when the petitioner, The petitioner, who is the owner of the vehicle, the owner of the car, is proceeding towards Davangere along with his friends and his family members. At that time, the first respondent has driven his lorry in a rash and negligent manner and dashed to the claimant's vehicle. And in the said accident, he has sustained injuries, and also his car is completely damaged. He used to earn an amount of rupees 50,000 per month. Per month. Huh? For everything, there has to be evidence. He used to earn 15,000 per month. The court below had granted an amount of 3,000 towards towards the simple injury sustained by him, and towards the damage caused to the vehicle, an amount of 50,000 was granted. Towards cost of repairs, no amounts were granted, and towards surveyor fees, another amount of rupees 2,000. Altogether, compensation of an amount of rupees 55,000 was granted by the tribunal. Learned counsel for the claimant submits that when he had spent huge amounts for repairing the said vehicle, court had not considered the same. He submits that he had, on his behalf, he has marked Exhibit P8, the survey report, Exhibit P9, the bill, and Exhibit P10, the estimate. It is submitted that both for the damage of the vehicle and to the bodily injuries, the amounts that were granted by the tribunal were on the lower side, and it's not a just and reasonable compensation. When the counsel appearing for the insurance company submits that, except stating that he is using the vehicle and is earning an amount of 15,000 per month, he has not adduced any evidence. Even with regard to the injuries sustained by him, no medical records were produced, and the court below had rightly granted the compensation. When it comes to under the head of towards cost of repair, the court below has observed that no evidence is forthcoming whether the replacement of the said parts was necessary. No one was examined. The person who was issued Exhibit P10 was not examined. And the court below had rightly granted the compensation. Having heard the counsels on either side, there was the entire material on record. First, coming to the bodily injury, according to him, he has sustained a simple injury. In respect of the same, except the wound certificate, nothing else has been placed before the court. As per the wound certificate, the injury is a simple in nature. Towards pain and suffering, the court below had granted an amount of rupees 3,000. This court is inclined to grant an amount of rupees 10,000. Then coming to the damages to the vehicle and for the repairs, court had rightly granted the amount of rupees 50,000 for the damages and rightly refused to grant the compensation for the cost of repairs, as though he has produced several bills, he has not examined anyone in support of the same, whether the such repairs were necessary or not. No evidence was placed on record, and then the court below had rightly granted the compensation of 50,000 and 2,000 towards survey fees. The survey fees, hence this court finds no reasons to interfere with the said findings of the tribunal. Legal expenses 10,000.
Sorry, sir. Right.
In the light of the law laid down in Mekala versus so, the claimant is entitled for an amount of rupees 10,000. It comes to 10,000, 50,000, 2,000, and another 10,000.
77,000.
Accordingly, the appeal of the claimant is partly allowed enhancing the compensation from 55,000 to 72,000.
My name is shown as appearing for Mr. Venkatesh, my lord.
Then counsel, Mr. A.M. Venkatesh, for the respondent, submits that. This next matter.
Serial number 17, madam.
Which one?
Serial number 17.
The file is there. Somebody else mentioned your matter. Yes. How much is the claim? No. How much was claimed? Compensation. Why you are looking at him? You are for the claimant. 3 lakh? 50? No. How much was awarded? 2 lakh? 2 lakh 1,400. 28?
2009.
28 or yes? 28, 11, 2000?
4,000.
Oh, according to you, how much?
10,000.
We will take 4,500. No charge. No charge. Insurance councils will not accept. To the whole body? Huh? To the limb? 13%.
Two injuries. So only 20,000 was awarded under.
2 fractures.
2 fractures.
Let's see that. Pain and suffering. Left frontotemporal scalp hematoma and left frontotemporal parietal diffuse cerebral edema.
Only 20,000 was awarded under.
What do you say? 40,000. Next, 2010. It's medical expenses. Medical expenses.
Legal expense. 41,291.
45,291. Then transport, how much is granted? Good, it's a good amount. Attendant and nourishment, 10,000 at that point of time.
Laid up period on 8,000.
1 month. It altogether, it comes to 16,000. Under 3 heads, good amount. Next, loss of earning during the laid up period. How much is granted?
8,000.
For 2 months.
2 months. Minute is only 10,000.
Laid up period, 13,500. Next.
Minute is only 10,000.
Or
Fractures.
the loss of future earning? No, it has to be calculated with 4,500. 4,500 into 12 into 17 into 13.
Minute is.
No, we are on, let's calculate this, we'll come to that. 4,500 into 12 into 17 into 13. It comes to 1,19,340.
Just like that.
What are the discussion letters? Petitioner had sustained left frontotemporal according to the medical records, had lack of concentration and recent CT scan for body changes in the left temporal parietal area may affect the abilities to be injured. What do you say on amenities? 10,000 is on less, injury to that, 30,000. Will expense. Comes to 2,74,131. Come. The present appeal is filed by the claimant seeking enhancement of the compensation agreed by the award passed in NDC number 1229 of 2010 dated 16 January 2013. The claim petition was filed seeking compensation of an amount of rupees 3,54,000 and the court below had granted an amount of rupees 2,01,400. It is the case of the claimant that on 28/11/2009 at about 6 p.m. he was going by walk on left side of the MC road in front of the petrol bunk in city. At that time, a motorcycle being driven in a rash and negligent manner dashed against the petitioner from behind. To the sudden impact, the petitioner had sustained multiple injuries and was admitted in Rajiv Hospital, Hasan, and then shifted to Nimhans Hospital, where he was treated as an inpatient, and the injuries have resulted in permanent disability, affecting his loss of future earning. According to the doctor, he had sustained how much to the limb?
40%.
40% to the limb, and to the whole body, how much? 13% to the whole body. The court below on the issue of negligence has held that the accident had taken place because of the negligence the part of the driver of the offending vehicle, and held that as it is insured by the insurance company is liable to pay the compensation. When it comes to the compensation, according to the doctor, the claimant sustained left frontotemporal scalp hematoma and left frontotemporoparietal STH with diffuse cerebral edema, and he took he took treatment as an inpatient at Raju Hospital, Hassan, and NIMS Hospital, Bangalore. Considering the injuries sustained by the claimant at the head of pain and suffering, the amount of the court below has awarded 40,000, which is reasonable, and this court is not inclined to interfere with the same. And even at the medical expenses also, court had granted 45,291 basing on the evidence produced by the claimant. Then coming to transport, attendant and nourishment, on the CH court below had granted 16,000, which is a reasonable amount, and no interference is called for. Towards loss of earning during the later period, court had considered 4,000, applying the ratio in Ramchandra case. This court is inclined to take 4,500 for 3 months. He is entitled for an amount of rupees 13,500. Then coming to the loss of future earning due to disability, considering the disability of 40% to the whole body and 13% to the limb, and rightly considered 13% to the limb, considering the income at 4,500 into 12 into 17 into 13 by 100, the loss of future earning due to disability will come to 1,19,340. Towards loss of amenity, as per the evidence of the doctor, the claimant had lack of concentration And the CT scan shows the total changes in the left temporoparietal area. And the site injuries may affect the area. Considering this, the court below had granted 10,000 as it's a head injury. Considering the evidence of the doctor, this court is inclined to grant 30,000 towards loss of abilities. In the light of the law later on, Mekala versus so towards legal expenses is entitled for an amount of rupees 10,000. Altogether, the claimant is entitled for an amount of rupees 2,74,131. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 2,01,400 to 2,74,131. The enhanced amount shall carry 6% interest. Pass over the. Yes, Mr. Krishnaswamy. Coming. First, it is, please tell the fact. She's a pillion rider. When the petitioner was proceeding along with one Jayappa, the pedestrian.
Not median right. The activities that taken place 2.5 years ago, subsequent to many of this thing, it is true that I do not know who had caused the accident. This is first. Second one is I am not aware as to who had caused the responding does not cause an accident to be.
The first respondent is the one who is driving offending.
It's correct to suggest that I did not went to offend on the same day, as I was not aware who has caused the accident. We do not know its true offending was. I have not stated before courts. In fact, that certain person had caused the accident to be. It is true to suggest that the motor vehicle which caused the accident belongs to or ability. It is true to suggest that the owner of the vehicle is N.B. Rajappa is my son-in-law. It is true to suggest that the first respondent is the son of Kapil.
That is the grandson. Grandsons. No, it is true to suggest the owner of the vehicle, Mr. N.B. Rajappa, is my son-in-law. It is true to suggest that the first respondent. N.B. Madappa. The remaining portion is not necessary. Remaining portion not necessary.
It gave to the date of occurrence of accident, health and all of the so next day, occurrence of accident, we have
So how will they know? How will they know who has caused the accident? So she says, she says the said person did not disclose to me as to who had caused the accident. I am not aware as to against whom said persons have filed the complaint. Ultimately, they will know about the involvement of vehicle from her. Hmm.
For the past year. That person did not disclose to me who has caused the accident. I'm not aware as to against whom that person has filed.
What do you say? What do you say? Oh, illiterate or illiterate, there should be something on, some evidence should be there. She denies it. She says she has not seen the vehicle which is involved in the accident. Later, she says that the vehicle belongs to, against whom the complaint is given, belongs to her son-in-law. And all the other persons, the first respondent who was driving the vehicle, has also come next day to the hospital. There, even at that point or time also, she doesn't know. So how to believe the involvement of the vehicle? Huh? Then how they came to know? Hmm. That's how that will happen. But your the evidence of the claimant itself is very doubtful about the occurrence and about the involvement of the other vehicle. Maybe occurrence, but about the involvement of the vehicle. Mhm. This is item number. Oh, you also filed an appeal for enhancement. Agreed with award passed in MBC number 651 of 2009, dated 3rd August 2011. Both the insurance company as well as the claimants have preferred appeals. The appeal of the insurance company is MFA number 1767 of 2012. And the appeal of the claimant for enhancement is MFA number 8051 of 2020. The claim petition is filed claiming compensation of an amount of rupees 5 lakhs for the injuries sustained by the claimant in the accident. There is a case of the claimant that on 29/12/2008 at about 7 p.m. when the claimant was proceeding along with one Jayappa on left side of this Jayappa was examined. Jayappa on the left side of the KR road behind LIC office as a pedestrian. The respondent number 1 being rider of the motorcycle came in a high speed with rash and negligent manner and dashed to the petitioner. Due to that, the petitioner fell down and sustained grievous injuries. Immediately, she was taken to Basaveshwara Health Center, Davangere, wherein she took treatment as inpatient and spent an amount of rupees 50,000 towards medical expenses. Prior to the accident, she was earning an amount of rupees 5,000, but due to the impact of the injuries, she is not in a position to work. What is that? First respondent is not. No, she might have denied it. Whatever the subsequent cross examination. what did you write? The code below on issue number 1 and 2 has observed that PW1 row has stated in the cross-examination that she does not know the rider and cause of the accident, but on page 6 of her cross-examination, she has specifically denied the citation made by the counsel of the respondent insurance company regarding non-involvement of the vehicle and its rider in the accident. The court observed that the burden again lies on the respondent company to prove that the bike in question was not at all involved in the accident. As the respondent company has not taken further steps, the court below considering the complaint, the charge sheet had held that the accident had taken place because of the rash and negligent driving of the rider of the offending vehicle and held that the insurance company, and as the insurance company has insured the vehicle, they are liable to pay the compensation. Then coming to the compensation, then then coming to the compensation, an amount of rupees 1,77,109 was awarded as compensation for the injuries sustained by the claimant. Then counsel for the claimant submits that the court below has granted only a meager amount of rupees 1,77,109. For the injuries sustained by the claimant at the head of pain and suffering, only 15,000 was awarded, and for the loss of income during the later period, only an amount of rupees 5,330 was granted. Then counsel submits that even the income that was considered and the amount that was granted at the head of loss of future income was also on the lower side. It is submitted that the court below the compensation that was granted by the tribunal was not just and reasonable. Then counsel appearing for the insurance company submits that when the claimant had filed the petition at 166, the burden lies on the claimant to show that there is the burden lies on the claimant to show the involvement of the vehicle and the negligence on the part of the offending vehicle. It is submitted that the evidence submitted that according to the claimant, she was walking on the road along with one Jalappa, what was his name? Jayappa, along with one Jayappa, and in a cross-exam, they have appointed an investigator. For the investigator, she has stated that the first respondent is not the one who had that the first respondent was not involved in the accident, and she has not sustained injuries because of his negligence. Further, in the cross-examination also, she has stated that the offending vehicle belongs to her son-in-law, and the first respondent is also the first respondent is son of one Madappa, and her son-in-law, the said Madappa, and her husband have come to the hospital the next day. In this case, the complaint was lodged the next day. Then counsel submits that when they have not examined the eyewitness, that is Jayappa, and when the claimant is not supporting the case of the claimant, was not when her evidence is not in support of their case, the court below ought not to have held the insurance company liable to pay the compensation, as the involvement of the vehicle itself is doubtful. In response to that, then counsel for the claimant submits that though she has stated that she do not know that which vehicle she do not know the details of the writer or the other details of the vehicle. However, she has denied in the cross-examination that the vehicle belonging to the first respondent was not involved in the accident. He submits that the court below had rightly considered this issue. Considered this issue. Yes, I heard the counsel on this side. That is the entire material on the top. The eyewitness to this incident is the claimant and as well as one Jayappa. Admittedly, Jayappa was not examined in this case. The claimant says that she has not seen the vehicle nor the person who is riding the vehicle. And she also stated that before the investigator visited their place, and she has stated that the for the investigator. Where do you get that, Mr. Swami? Investigator has come to her and about stating before the investigator that only to that investigator, she has accepted that the investigator has visited her house. It is stated in the cross-examination that she has not filed a complaint on the same day, and she was not aware who has caused the accident. And the owner of the vehicle, Mr. N.G. offending vehicle, Mr. N.B. Nanchappa, is none other than the son-in-law of the claimant. And Rajappa, claimant, first respondent, that is the rider of the vehicle, is son of Madappa. It is also stated that after the next date of occurrence, to see her husband, Madappa, Hemant, Jayappa, Basappa, Basvarajappa had visited the hospital. All the evidence of the claimant clearly shows that the vehicle has been implicated in this case. The claimant had failed to substantiate their case by leading cogent evidence. The court below had wrongly shifted the burden on the insurance company when the initial burden lies on the claimant to prove that there is involvement of the vehicle as well as the negligence. In that view of the matter, the appeal of the insurance company is allowed, and the appeal of the claimant is dismissed. The amount in deposit shall be forthwith transmitted to the court below. The insurance company is at liberty to withdraw the same. That's what that is here. No, somebody says that it has to be. That's what. No, even this also one of the insurance companies. Liberty to withdraw the same. Yes, next. Withdraw the same, not to the court below. Here only. Yes, next. Serial number 14.
Number 14. In Somshekara.
We appear for the insurance company.
18. One back.
You ready? Where is the, who appears the respondent? Mr. Mahesh?
Serial number 14. Oh, Mahesh, sir.
Yeah.
Oh, Mahesh, sir.
Your matter, are you ready?
Serial number 14, sir.
Serial number
Ah.
4,
Please, madam.
are you
Madam,
ready?
I had sent a message to the insurance company, but there is no reply. The appeal memo said to have been served on me was sent to them, requesting them to send the wakalat and also court records. There is no response.
So what is to be done now?
But I am in a helpless position. Because the judgment is also not available in the website to assist the court.
He says judgment is not available. Give him one more copy, we'll take up day after tomorrow. Post is marked day after tomorrow. At the request of non-counsel for the appellant. This next.
Number 19, taken me.
It's law. The invalidating compromise. We find nothing to be on the. Maybe ask my not in state. My friend, property from the he wanted not being able to.
How much is granted with the court below?
15 lakh 20,000 was granted. The claim only was tax. So I will give you that. I will give you another 10 lakhs. How can you yes, disability 100%. Entry for future prospects. Logic is this one. To earn that money, you have to spend yourself. Just in the pay. The
According to him, if that 100% is taken, how much you would get?
it comes around 20 lakhs. So he should keep 1 lakhs in every day. He got more than what he was earning. It's not the principle of damages. What the principle says is the entire money should get spent by itself but carefully. That is the principle. So something reasonable. Like I know that I did not reserve. I have strong laws. Something very reasonable.
No, I know, but no.
Pension has to be given. Pension details you have not given. Pension, you cannot have both. You cannot get 100% from me. 100% salary. That's also the pension. You lost that. Pension has to be deducted.
It's no some judgment has been. That is regard Supreme Court judgment. Where is that?
Yes, the disability state, we are asking for injuries. Compensation.
In case of death in Virendra Kumar's case, it was considered.
Yes, pension is because services rendered and my pension will be getting application. I cannot ask for a reduction.
You have any judgment? No, you have any judgment? When do you want?
But
And the request of both, he will not agree for the settlement. And the request. So negotiations are going on from morning. What was granted? 14 plus 25. You're ready to give? 15 lakh, he is ready for 30. Now what is 15? You already have. He's ready to give another 15. It becomes 30.
What I'm saying is,
Do one thing. No, search for the judgment. If you don't get a judgment, then come up, be happy with 30. We'll pass orders after 30. At the request of both the councils, post this matter. On the reopening day. 26. Post on 26. 20?
For the respondent, my lord.
21?
For the respondent.
You are for the respondent. Who appears for the appellant? There is no representation on behalf of the appellant. Then counsel for the respondent is present. Post for dismissal tomorrow. Yes, next.
Number 22 and 23, number 24. It is good day, sir.
He will hear from morning.
Number 24.
Respondent.
Sitaram Rao.
Tomorrow,
Tomorrow. Tomorrow.
Tomorrow.
Post for judgment tomorrow. Item 24.
Number 25.
Learn counsel for the appellant not present. Counsel for the respondent present. Heard in part. Post for judgment tomorrow.
Number 25. Parish Bandarity.
Yes. No representation for dismissal tomorrow on behalf of both the councils.
Number 26. Jayadevappa.
Ready? Yes,
Right
Mr.
here for-
Item 26.
Yes, I am ready.
Oh. Yes. Yes. Case of death. Liability is only for enhancement? Oh. How much was the claimed amount? 20 lakhs. How much was awarded? 6 lakhs.
35,000,
What was the age?
33 years,
Occupation?
milk vendor,
Income?
15,000 per month,
According to him, how much is earning? 10 to 15,000. Court has taken?
5,000.
Which year is the accident?
2008, it should have been 4,500. Instead of that, 5,000 has been taken.
You know, it is there. So 5,000 is granted. There can't be any enhancement on that. So future prospects were considered. We will consider future prospects. Now, who was examined?
Wife was examined.
What did he say? What do you say on that, on the income?
But 5,000 has been taken for an accident of 2008. It should have been 4,500.
No. He says he has adduced the evidence to show that he is earning 10 to 15,000, and PW2 examined as a deposed that he is supplying 30 liters of milk and some card is there.
But there is no regular income as such, my lord, to consider what is claimed by him. Is not.
Please let's see that portion of the order with regard to this PW2's evidence and all. Page number 18. Come about from the half of the page you read. He was a sericulturist.
It is only a copy of that, my lord. It's not even a thing. It is not proved. How much he was supplying, what was the income, there is no supporting document. And it would be a loss of service rather than loss of income.
Now, if you are receiving 9,000, 10,000 by supplying the milk, that cannot be your monthly income. Where from? For if you are having no. If you are having where from you are getting the milk? Where from you are getting the milk? You are getting. So if you have a card, you have to pay some money for that. Society will not give you the features of take the entire amount. Definitely it would want to what 30 liters. And according to you, you are receiving 9 to 10,000 per month. Per month. So in that something you have to pay to the society. Definitely half of it. Who said so? All that. Is it in Kannada or in English?
Well, his number came out. No,
Let's see. Because without evidence, how the court can consider? No, more or less this amounts to a case of no evidence. Yes. Now what is Exhibit P7? Yes, and it is evidence that that is not sufficient. Your income tax. So yes. You have to tell how it can be.
Although in case Nadita to cut on
Hey, sir. Lot of disturbance from your side, sir.
I'm sorry, my lord, no, outside.
Give the lower court record. That's what you are there for supplying the milk. You are receiving 9 to 10,000, and that cannot be no. That's what I'm reading. For supplying the milk to society, he was receiving a sum of rupees 9,000 to 10,000 per month.
30 liters means Every day you.
I think you understand what the court is referring to.
Then without. Certificate.
Certificate will not give you any. At that point of time, it has to 4,500, court had taken 5,000. Yes. How many are the claimants? How many are the claimants? Three. One third. Comes to 2,333. Your contribution to the family would be 4,667 into 12. What is the multiplier? 16. Into 12 into 16 is 8,96,064. 3 into 44 is the consortium. One lakh 32,000, 33,000, 10,000. Comes to 10 lakh 71,006. Everything was granted. 1,32,000 towards consortium, 33,000 towards funeral expenses. Yes, Mr. Mahesh, 10,71,064. You have muted your audio.
The concept of future prospect and the consortium was not there when the judgment was pronounced by the tribunal.
Oh, even consortium is not there, and the future prospects are also not there.
No, the quantum of this thing, amount allowed under those heads, it was there, but it was not there.
Please come. This is an appeal filed by the claimant. Agreed with award passed by NBC number 4088 2009, dated 28th April of 2012. The claim petition is fetched for compensation of an amount of rupees 18 lakh for the death of the husband of the first claimant and father of the other claimants in the road accident. The case of the claimants is that on 25/11/2008 at about 6:14 p.m. the victim was the victim, the deceased was running a milk he was proceeding on a motorbike on the extreme left side of the road at Kamasa Mundram, Kopanahani Road, and he reached near Kamanam Westcom Power Station. By the time a motorbike came with high speed in a rash and negligent manner, dashed against the deceased, due to which he died on the spot. After conducting the postmortem, the dead body was handed over to the petitioner. They have spent a lot of amounts for the funeral expenses. The court below, according to the claimants, he was earning an amount of rupees 3,000. He was earning an amount of rupees 15,000 per month by doing milk vending business and sericulture. The court below had considered the income at 5,000 and granted an amount of rupees 6,40,000 and the head of loss of dependency towards consortium 10,000, loss of common defection 10,000, loss of estate 10,000, transportation, funeral and optic to 5,000. Altogether, an amount of rupees 6,35,000 was awarded. Then counsel for the claimant submits that he had examined PW2 in support of his case to show that petitioner was supplying 30 liters of milk every day and he was getting 9,000 to, he was being paid 9,000 to 10,000 per month. Apart from that, he was also in sericulture and earning amounts quote below had taken only 5,000, which is on the lower side. He submitted that the compensation that was granted was not reasonable. Land counsel appearing for the insurance company submits that though he has examined PW2, he could not establish that he is earning an amount of rupees 10 to 15,000 as stated by him. This is an accident of 2008, 2008 or 9? 2008. The quote below, instead of taking 4,500, had taken 5,000, which is already on the highest side. Submits that no enhancement, the claimant had failed to make out any grounds for enhancement of the compensation. In this case, the liability in this the present appeal is only for enhancement of compensation. According to the claimant, he is earning 10 to 15,000 by doing the milk vending business, and he is relying on the evidence of PW2. This court has perused the evidence of PW2. According to them, he is supplying the milk to society, and they are paying 9,000 to 10,000 per month. That cannot be taken as a definite and monthly income of the claimant, as you would have to spend a lot of amount from the said amount for the amount. This is a case more or less for evidence with regard to income, and taken 5,000, 5,000, which is on a which is adequate. Hence, this court is not inclined to enhance the. Is not inclined to interfere with the same, as he is aged about 33 years. Future prospects would be at the 40% come to 2,000, that is 7,000. As there are 3 claimants, 1/3 has to be deducted towards the personal expenses. That is 2,333. Comes to 4,667. And the contribution of the deceased to the family is 4,667. If you 12 and the relevant multiplier 16, it comes to 8,96,064. As there are two children and wife towards consortium, they're entitled for an amount of rupees 1,32,000. Towards funeral expenses 33,000. And in the light of the law laid down in Mekhala also for the legal expenses, an amount of rupees 10,000. Altogether, the claimant is entitled for an amount of rupees 10,71,006. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 6,75,000 to 10,71,064. The enhanced amount would carry 10%.
Please.
Huh? It will be released at all. Why there was an order from the court below to deposit, keep it in the fixed deposit? No. If you submitted that, anyway, you have to make a petition there for withdrawal of the amount. If they have attained the majority, automatically court will grant. Forever, lower court order is forever, it should be kept in deposit. We'll see. Yes, yes. $25. What?
Serial number 25.
But yes, respondent. Mr. Swami. Is not here. We'll call the next matter, let him come. We'll call the next matter, let him come. Mari Gowda. Is there online? Call the name.
Marigowda. Serial number 27.
My lord, I am preparing for the appellant in this case. My lord.
Yes.
Lord, this owner's appeal. My lord,
Owner's appeal.
Owner's appeal. My lord. This is owner's appeal. And this is a second round of litigation. I request you to kindly take the page 7 of the trial court judgment. My lord. Page 7. Immediately after the judgment, this court has dismissed the petition.
What are these two appeals?
My lord, the one is I am the owner, the other appeal filed by the claimant for enhancement. The other appeal filed by the claimant for enhancement. So this honorable court, my lord, in second law litigation, in the ink page 2, second line, no doubt.
1 minute, Mr. Gowda. Yes, Mr. Ravi. No, initially it was dismissed. Claim petition was dismissed. After remand, it was fastened on what ground that was? No, on what ground you are absolved from the liability?
But on the way, legal hearing, the complaint was lost after few days. And apart from that, no legal issue. He's a friend. He's a advocate. I'll get for what.
No, in that case, the involvement of the vehicle itself is doubtful, then how the owner will be liable? Okay. On collusion, no, it's. No, but the other circumstances, generally, your insurance company in all the cases will say that the vehicle is not involved. Please. Is there any relationship between them? That was listed in the evidence. No, what is the date of action? 23/4. The image of, oh, after remand and all, 1998. When was the complaint given?
Sometime 98.
5/5?
98.
After that, there's a long delay, that is 7 days plus 5 days, 12 days. And when they were taken to the hospital, and any hospital records are filed, what do the hospital records say? Give the record, lower court record. You are referring to exhibit? From Kuroda. Own certificate?
It means seven. It was done on 24/2019.
It is, there is instrument. It is P8. P6. It is not, oh, it's called Kim's.
It's stated on in photo filters.
A history of MLC. RTA also around 9 AM.
Done on 34/98. There is a request of Mr. Pinte Loda, brother, following the movement. RTA and delivery to 33/98 around 9 PM while traveling on a two-wheeler to Sweden for.
Vehicle Hero Honda number so and so. This is the one which is traveling.
Here it is mentioned that
Probably this is the one on which he's traveling.
it's traveling on 468.
This is the vehicle.
Here it is written as 4680.
No, 380.
It's like 880.
Something like 3, it's 38.
The reason is
So at the earliest point of time, it was informed to the as per this skills hospital MLC, this wound certificate, it is wound certificate reveals about the RTA.
Yes.
And his case is that he was traveling on the two-wheeler.
Yes.
That is also correct.
The fact is now, there is a delay lodging the complaint and other things.
What is the explanation for that?
I did have
From the order?
further it is considered.
Though he admitted on 23 for 1998, but the RTA was, this MLC was done on 30 at their request.
Yes. These are all the facts. It's true.
No, I was under the impression that on the same day it was made. Of the respondent?
Flexible from the accident. He did not take the.
Yes, Mr. Yes, what do you say?
Lord, I request your lordship kindly have it this matter. Tomorrow I will come and make my submission.
Tomorrow for judgment.
Yes.
For this matter. Tomorrow for judgment. This week. Tomorrow. There is tomorrow. This also tomorrow for judgment, item 25. Next.
Number 28. Please be Bandare.
This is not going to Bandara. Harish Bandara. Any matters who are ready?
Your Lordship, seal number 31, my lord.
You are ready?
Yes, my lord. Three
Who
connected.
appears for the respondents?
I am for the respondent number 2, my lord. 3 connected matters, my lord.
You will take up these 3 matters tomorrow for judgment.
Please, my lord.
Post matters for judgment. You are ready? Where is Krishna Swami? Is not here.
Similar matter connected already.
This also judgment for tomorrow judgment. Item 30.
Serial number 29 also, Malad.
He's here. You're ready? Sita is online. There are two claim petitions. Two claim petitions. What are those numbers? Please come to the order. MBC number 77. Case of a rider and pillion rider. Who is rider and who is pillion rider? Which case? Pillion rider. What is the corresponding appeal? 9839. MBC 78. Rider of the vehicle. Appeal 9841. Let us see why the your claim petition is this. When did you give the company the date of accident? Yes. 7/11. 7/7/2011. 2007. When was the complaint? In that you mentioned a different number.
Next day,
Hmm.
our filing complaint, and the vehicle number mentioned as A11, J1890.
What is the offending vehicle number now, according to you?
Next day, your product state, there is a time of accident, the field is complaint study. So I was in the staff, so the people are there.
What is the correct number now? Two eight. Two numbers are there.
But he clarified by the further.
Very next day. Now please come to the order.
And further statement is that it will be
Para number. Hello? We'll continue tomorrow. Don't think we can finish it today. Both these matters for judgment tomorrow. Why not? You don't want it tomorrow. Serial number so and so. Yes. All tomorrow matters are fine. And she's writing now. Done. All the other matters are also done. How many are the disposals to do? How many?
ಇಲ್ಲ ಬತ್ತಾ 32 ನಾಳೆ ಅದಲ್ಲ ಅವ್ರು ಬೇರೆ ಮಲ್ಬೇಕಾ ಎಸ್ ಮೇಡಮ್ ಇಲ್ಲಿವರೆಗೂ ಬರ್ದಿದ್ದೀನಿ 32 ಇಂದ ಇಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ ಎಲ್ಲ ಇಲ್ಲಿದೆ ಹತ್ತು 2 ಗಂಟೆ ತನಕ ಹೋಗಿದೆ 2 ಗಂಟೆ ಚೇಂಬರ್ ಅಲ್ಲ ಅಲ್ಲಿ ಮನೇಲಿ ಕೆಲಸ ಮಾಡಿರೋದು ಇನ್ನ 20-30 ತನಕ ಕೊಟ್ಟಿದ್ದಾರೆ ಡ್ರಾಫ್ಟ್ ಎಲ್ಲ ಟೈಪಿಂಗ್ ಟ್ರಾವೆಲ್ ಕನ್ನಡ ಕೊಟ್ಟಲ್ಲ ಡ್ರಾಫ್ಟ್ಗಳನ್ನೆಲ್ಲ